I am Mark Webber. I'm a partner at a law firm called Osborne Clarke. I'm a technology lawyer. I only do deals in the technology space and been working from .com through years of outsourcing now into SaaS and cloud, and work with a balance of users of cloud services but also a number of cloud providers. I've had a particular experience of 3 years working out in Silicon Valley, working with a number of businesses who are bringing their services over to the UK and to the rest of Europe. Challenges with cloud are quite interesting because it's quite a nascent, evolving area, and there's a lot of good sales, there's a lot of good hype out there, some of it very positive, and there's a lot of opportunity. But what people aren't doing necessarily is drilling down into the background, understanding what they're doing in relation to the cloud and why cloud is different in relation to the deals that they may have or when they keep their services in-house and within their own operations. The thing about cloud is there's no particular law that's specific to the cloud space. So what we're doing is really applying old law and old principles to work out how that bites upon businesses that are going into the cloud. There's definitely a lot of uncertainty, a lot of FUD, the fear, uncertainty and doubt out there, where people are hearing mixed messages, hearing sales presentations which mix up concepts, and it's quite good to cut through and explain to them a little bit about what the real principles are and the fact that going into the cloud isn't necessarily an impossibility. I'm definitely seeing a lot of legal reporting and articles which are very negative in respect of cloud, but I'm a big believer in cloud and the fact that you can deploy cloud effectively and legally if you're careful. Well, I think the thing we've been discussing today in particular is this legal term of due diligence, but really going in with your eyes open. One of the big problems with cloud is the legal perspective is thought about at the last minute. It should be something that's considered right from the very beginning, at the point you're considering going into the cloud. What are the issues, and do the issues mean that I'm better going with a certain type of vendor, or I'm better going with a certain type of deployment? So really looking under the hood of what you're about to do is important, and we've discussed quite a bit today about getting the technologists involved alongside the lawyers, so there can be some interpretation of what the law is but also how the technology is working. So I think that's point one. Secondly, I think bearing in mind that a lot of cloud services are in their sort of embryonic phase, and really taking a moment to say, is the contract that's being put in place something which really reflects what we're doing? People are driven by the cloud providers at the moment, which is not necessarily a bad thing, but a number of them will have contracts that are drafted in favour of them, and in terms of principles they may well have originated from the US or other countries and not necessarily reflect what is taking place in Europe or in relation to that particular deal. So again, looking at what's there. Thirdly, I should say, you should really be thinking about questions of data. What's happening to that data? Am I protected? If I'm a custodian of that data, is often the case. If it's personal data, things like the Data Protection Act might bite on them. If it's other types of data, there may be confidentiality obligations, trade secrets. You need to really think about that data. I'm passing it to a third party. What's important in relation to that data? Am I legally allowed to do it? Am I contractually allowed to do it? Do I have obligations to other people? And then when it goes to the cloud provider, the fourth consideration is really, who do they deal with? Well, who provides connectivity? Who provides their services? I may be dealing with company X, but really is the data center run by somebody else? So really looking at the stack, as we've talked about today, and seeing who underneath the relationships is involved in providing the ultimate service. And then finally, I think we look at the fact that a lot of these deals are not particularly easy to negotiate because they're very much take it or leave it. It's often low price point. It's often a service which has been offered to a number of users or multi-tenanted. It doesn't work for the service providers to spend a long time negotiating, and it doesn't work for the service providers to make custom changes to contracts and processes, which means they've got to do things that are different to the other customers that they've got, and that can mean we lose economies of scale, and it can be very difficult for them. So to some extent is getting sympathetic and really working out what the key points are and what really needs to change. And if you do it in the right way, maybe the whole industry will change. But at the moment we're really exploring in a number of areas exactly what looks like good cloud contracting practice. So today's event I thought was very useful. It's the first, I've been to a number of cloud circles, but the first time I've been properly participating. It was very, very good to see the level of interest and the level of prior understanding, but I think most important was the fact that it was workshop style, and there was a lot of interaction, and I think questions could have gone on for hours, and people have got very relevant questions and they're applying them, and to some extent I was pleasantly surprised by the level of interest, particularly when you've got a legal topic. You're not really sure how many people really want to hear the law, but we sat through a number of speakers, and I think everyone went away with a good feeling and some more information about what they're looking to do in the cloud space.